First, let me thank everybody for commenting on my video. I'm honored so many people have watched and commented. I'm here to respond to some of those comments because I've been trying to do it in writing. I'll apologize for my appearance. I just got back from coaching my 9-year-old son's first Little League practice ever. I've been criticized for not getting into my analysis until 9 minutes and 56 seconds, which is a completely fair criticism, as well as criticized for my comment regarding the timing. So in that spirit, I will get into my analysis immediately. The first comment I want to address is one that was raised regarding potentially George Floyd having actually overdosed because of his tolerance having dropped, because there was a fact witness who testified that he had tried to quit using opioids for 2 weeks prior to this incident. While it is true that I believe the woman who was a fact witness in the vehicle did testify that he had been trying to quit his use of opioids, I would like to point out that as a criminal defense attorney, I've lost many a client to opioid overdose as a result of their tolerance dropping significantly and then them overdosing. This is usually a result of them being arrested and being placed in on a bond that they cannot make for a matter of months, then them somehow coming up with the bond money after a matter of months, getting out of jail, and then immediately using the amount of opiates or opioids, be it heroin, Oxycontin, fentanyl, whatever, that they used to use, and instantly overdosing because their tolerance had dropped while they were in prison and they had overdosed and died. There's a difference here in the George Floyd trial. First, there's also a comment from a law student that I'm going to address regarding certifying expert witnesses, but let me just address the difference between a fact witness and an expert witness. A fact witness can only testify in a trial as to something that they themselves personally witnessed, physically saw, heard. They can't testify to opinion. They can't testify to anything speculative. They can't testify to a hypothetical. Expert, the exact opposite. But there has to be a special foundation laid, which I'll get into later when I address that comment. The woman who testified did testify that George Floyd had tried to quit. However, she did not make any comment as to technically how long ago that had been, if he had used since that time, anything like that. And I'd like to point out, in my experience, granted, also, there's someone who left a comment that they are impressed with the defense in this case. Obviously, I, as an attorney, my opinion of what's going on with the defense means way less than what a layperson is, because the jury is intentionally comprised of lay people. So if there is a layperson who's impressed with the defense in this case, then I may be completely off base as an attorney, because the jurors are not attorneys. They're lay people. So my hat is literally off to you if you're impressed with the defense in this case. Perhaps you will be acquitted. But getting back to my experience, when they are held on that bond, it takes more than 2 weeks in order for their tolerance to drop. And this was actually raised. I went and rewatched the expert testimony. And the doctor who was testifying, Dr. Smock, actually was asked during cross-examination regarding tolerance falling and the amount of time, and he did state that it would not happen in a matter of days, that it would be a matter of weeks to months. And that is because in order for your tolerance to fall, you need to get through the period of withdrawals from opioids. And I don't know if you have any experience with opioids or opioid addicts, but the withdrawal symptom period can last anywhere from 4 to 6 weeks to 6 months. So you won't actually experience that overdose until you've gotten through the withdrawal period and your brain is making the correct amount of dopamine on its own and doesn't require that opioid to put the right level of dopamine in your brain, so all those with nasty withdrawal symptoms are gone. Then you go out and you take your usual dose, you have the natural dopamine in your brain, you overdose. So there's been no testimony regarding the fact that this was his first time using since having quit. It's precisely how long he had quit for and when that was. There was just a passing mention from a fact witness. So I'm highly doubtful that you'll see the defense, although I will concede that it was raised during the cross-examination of Dr. Smock very briefly after watching it, which was odd because he's not the toxicologist. He was brought up immediately after the toxicologist, but the defense did raise it, and the judge has been very broad in what he's allowed the defense to bring in. So it is possible that it will come up in closing, that they will attempt to make that closing argument. So my hat is also off to that viewer. for bringing that point up. Although, I have to say, if I were on the bench, I wouldn't allow it. I don't think there's been enough foundational evidence to make that, to complete the circle. Dr. Smock kind of shut that whole thing down to the point where the state didn't even address it on redirect. Additionally, as far as my comment regarding the timing of this and how Derek Chauvin may be convicted because of the timing, that's only because I was bringing up the Amadou Diallo incident with the 41 shots where they had him in a foyer to his own apartment, shot 41 times by the police unarmed. The police were indicted, but they were not convicted because the blue wall held. Rodney King, we had video evidence of the beating. Everybody thought, especially back then in those days when video evidence was unheard of, it's a shoo-in, they're going to get convicted. Acquitted, the blue wall held. In this case, the blue wall has not held. The blue wall has all but crumbled. The police have been lining up to testify against him, which another viewer pointed out the fact that the chief of police stated that the knee wasn't always on his neck and that it moved around. I don't know that that's going to have so much importance in the case. And with that, let's touch on where we're at. The defense and the state have gone through the charge conference, which basically is the part where the judge comes up with what instructions he's going to give the jury, because you can't make your closing arguments. And I should point out, there's a difference between opening statements and closing arguments. You'll notice that the defense actually asked for an instruction, if you were watching the charge instruction portion, regarding the witness that pled the fifth about being in the car with George Floyd because he could potentially be convicted of constructive drug possession. That's like this piece of paper. If I put it between me and someone else, we're both legally in possession of it. It's called constructive possession, and since drugs were found in the vehicle, he technically couldn't testify he was in the car because he could have been indicted after the fact, and there's, under that third-degree murder statute, he could technically, or it's either the second-degree manslaughter or the third-degree murder statute. There's something about if you gave drugs and someone overdosed, it's the second-degree manslaughter. It's part B. If you gave someone drugs and they died, you could be responsible. So he actually, if God forbid Chauvin was acquitted, could be convicted as a result of it. So that's why he took the fifth, and they asked for an instruction because during opening statements he had told the jury, you're going to hear from this guy. And that's what I want to make the difference. Closing arguments, you actually argue based on only evidence that's been admitted in the case. You can't go outside what's actually been brought into the case. So you're limited to what evidence has actually come in through testimony, documents, stuff like that. Opening statements, obviously, there's been no evidence. So you're not really allowed to make an argument. So people call it opening arguments. That's not accurate. It's a statement of what evidence you anticipate showing the jury. And the defense counsel was wise to ask for an instruction to tell the jury, you know, it's not our fault that this guy took the fifth because he doesn't want it to be held against him, that he told them they were going to hear from this guy, and they didn't. So they're through that charge conference. Basically what it is the state introduced potential instructions that he wants from the jury, and these instructions range from things like circumstantial evidence is just as strong as direct evidence. Direct evidence would be you walk outside, it's snowing. Circumstantial evidence would be you're sitting at your job in a cubicle with no windows, somebody walks past you and they're covered with snow, they have on snow boots, and they're shaking snow off their body. It's reasonable for you to infer it's currently snowing outside even though you don't have access to a window. That's a standard jury instruction. They're arguing over the precise instructions that are going to come out on the elements of the crime. The reason why they're trying to get this is because when you're an attorney and you're making closing arguments, it's very important for you to know what the judge is going to instruct the jury, the law is going to be, because you have to tailor those arguments to that instruction so that you don't argue something that then is contradicted by the judge's instruction. So as of right now, the judge is taking it under advisement, what he's going to do, because the judge usually comes up with his own, state proposes them, defense proposes theirs, they argue about it. In this case, the judge kind of said, I'm going to take some of your suggestions under advisement regarding the elements of the offense, what needs to be proven, stuff like that. So we're going to see what he decides is the jury instructions, I presume, which, as I said in my previous video, it's the most boring part of a case. I mean, I don't even think they'll televise it because it's just like, it's the worst part of every trial is jury instructions. It's the hardest thing not to fall asleep as an attorney, especially since you have a pile like this with the instructions right in front of you and you're following along, reading as the judge is instructing the jury, and you're just like, oh, it's just terrible. But that aside, there was a law student who had said that how to certify an expert was a question that she had and that watching this trial actually helped her out because it's a nebulous concept. Now, some of you may remember, this is a little off topic, but Donald Trump had one of his judicial nominees for the federal trial bench didn't know what the Daubert test was. Well, that's funny because the Daubert test is the current test for certifying an expert. Now, it was the Frye test before that. The Supreme Court overruled and threw out the Frye test. The Frye test basically let everything come in. They said, whatever wants to come in, you come in, let the jury sort it out. That's a loose definition. The Daubert test has been more constrained. So for her sake, anybody else watching can basically just click off now. I'm trying to make this one much quicker than the last one for you guys, just so you know. I just want to say thank you for your comments. I'm touched. I've been trying to respond in writing, but I figured a video would be quicker, better, and more respectful to all of you for your time. But to that law student, the Daubert test holds that the expert has to just demonstrate that the theory or technique employed is generally accepted in the scientific community. It's been subject to peer review or published. Whether the opinion can and has been tested that they're offering. Whether the known potential rate of error is acceptable, which is a weird one. And whether the expert opinion can stand alone of the litigation, meaning the opinion was reached or the determination wasn't reached specifically for the purposes of the trial. In other words, they're not a hired gun. Usually you can satisfy all of these just by showing the person has adequate education in their field, adequate employment in their field, and that they have had either editorial or writing of some journal or former testimony that was public that has been peer-reviewed. If you can get the witness to answer those questions, that yes, I've been educated in this field, yes, I have worked extensively in this field and relied on the scientific method in my work, and I have been a part of either, that's why if you watch the toxicology, or maybe it was the one after the toxicologist where he held up the books that he had published or been an editor of, you need to get their educational background, their employment background, and then anything that they've published either through editing or writing it themselves, or you can actually use previous testimony that they've used if it's in the same area, because that would have been subject to peer review. And you can determine, the rate of error and stuff like that from that. So that's just to answer that question. If there are any further questions, again, I'm not here to criticize anyone. I'm open to criticisms of my opinions on this. Like I said, I'm an attorney. We intentionally don't put attorneys on juries. I've been called to jury duty and never been picked because I do trial work on both the criminal and civil side. Civil side, I have to prove the case, though by a preponderance of the evidence, which is just slightly more likely than not proof beyond a reasonable doubt, and obviously criminal defense. So I've been on both sides of the ball. So nobody wants to take me. So actually your opinions of how the trial is going means a lot to me because it lets me see the case through the eyes of a non-lawyer because I'm tainted. But I do still stand by my earlier statement. I think 9 minutes and 52 seconds, whether he was on the neck for the whole time or not, I think the states more than carried their burden in this case, and I think with the police, it's going to be over. But I just wanted to say thank you to all of you for your comments. Even those criticizing me, I welcome it. It makes me go back and watch again and find things that I didn't find. So I thank you for your criticisms. I hope I got into my analysis fast enough for everyone and kept this video short enough for everyone, although I noticed it's running long again. So with that, I'll say thank you to everyone. I'll put it up again and appreciate all the comments and everyone joining in. Thanks. Well, and I'll obviously comment at the end when this is over. Thanks. Bye.